I obtained same from him in court on that day. So invariably, my lord, we were not caught by time at the last proceeding.
Okay.
Yes, my lord. So we miscalculated, and I was even expecting, although the council might also have forgotten, and they are not expected to do our case for us, but we were not caught up by time at that last proceeding. So we were still within our time to file our addresses. So if the council had averted his mind that, okay, truly, if it was on 8th of February, so he wouldn't have sought for the cause sought for on that particular day. We were supposed to even be the ones seeking for cause, which we impliedly waived. So now to the cause of today, my lord, as I said earlier, we are ready, although we apologize for the delay.
What about the second? What about the second defendant? When did the second defendant serve you the second defendant? When were you served with the second defendant's address?
I don't know.
Yes, Mr. Hafiz. Yes, Mr. Hafiz. Maybe we have lost him, huh?
Hey.
Yes, Mr. Abdullah. It's like we have lost him. When did you serve the claimant with your final address?
My lord, we served on the 8th of February.
8th of February.
That's on the 8th of February. On the 8th of February. 8. 08.
Okay. And from that time, he has 21 days to react to your final address. Is that so?
Yes, my lord.
Yes, my lord. Just 1 day to respond. And by my calculation, I'm trying to calculate 1 day. My lord, the 21st day. Hello? My lord.
Yes, I can hear you.
Yeah, the 21st was on the first day of March. The last day, the last day of thing was the last day they are five. They are acting out.
Abdul, the claimant was okay, and Hafiz is back.
Yes, my lord, I'm back, my lord.
Okay, yes, I can hear you.
So as I was saying, my lord, the first defendant served us on 8th of February. The second defendant served us sometimes in December. So we by law,
yes,
by law, we were to receive the written address of both defendants before we will file our own final address. So the last one is what we reckon in counting days. By calculation, 9th of February to 28th of February is less than 21 days, which we have to react, my lord. So that was why we were saying we were still not out of time. Not proceeding, despite the miscalculation by us and also by the council not diverging that particular fact to the court.
So you are not out of time as at the last agenda date?
Yes, my lord, we are not out of time, my lord.
As at the last agenda date?
As at the last sitting, my lord.
But as of today, we are out of time.
Exactly, my lord. We are out of time. My lord.
And that's what they're asking for, course.
My lord,
I'm sorry, my lord, I could barely hear anything apart from the sound.
So, Mr. Abdullah and Budom, let's first take the application for extension of time, right?
my lord,
Yes, Odum and Abdul. Abdul,
I have no objections, my lord.
Okay. So Hafiz, can you move your application?
Yes, my lord. And my lord, I think I'm not the only one having application for extension of time among the council. Other councils also have.
Okay.
Yes, my lord.
I have an application, my lord.
Who has an application for extension of time? Again.
I have one, my lord.
Okay. Okay. It was not taken on the last agenda date.
It was not, my lord.
Oh, okay. So, Mr. Odum,
My lord.
you have an application for extension of time.
Yes, my lord.
When was it filed?
It was filed on the 17th of January.
Okay, but why wasn't it taken? On the last agenda date.
My lord, on that day, the court was pressured, and my lord was stuck in traffic, and my lord was disposed to winding up, and that was the circumstance that day, my lord.
Because your final written address has to be in first before claimant files his own.
As the court pleases.
So once your application for, does also Mr. Abdul have an application to extend time?
No, my lord, we filed within time.
Okay, Abdul filed within time.
With the second.
Okay, so Odum, your application is dated on file.
Yes.
My lord, if I may seek this clarification, my lord.
Yes.
Mr. Abdullah said you filed within time. You served us on February, and the last proceeding in the matter trial was in December. So
yes, he might have filed in that December or in early January.
Okay, as the court pleases. I'm checking.
Abdul, when did you file?
My lord, we filed on the 8th of February, the same day we said it.
If you had filed on the 8th of February, then it means you are out of time.
As the court pleases.
My lord, we're not out of time because our time started counting from the moment we did the second defendant. From the moment we received the defendant's final address.
Okay, you mean the second defendant has to file before you file?
That was that was even the order of the court on the day on the day the matter, the
Okay.
defendants closed their case.
Okay.
Milord, I see the God's guidance in this at this junction, Milord. I have not come across such kind of a rule that says defendants are defendants in the matter. So one defendant waiting for the other before it's
no, but there are different defendants now.
Yes, Milord. Yes, Milord. There are two defendants, Milord.
Yes.
So, and they have different cases. So one waiting before filing. The rule does not provide for that, Milord. I don't know if Mr. Abdullah can point us to the rule where he says he must wait for second defendant before he files his own address.
My Lord, if I might come in here, my Lord.
Yes,
my Lord, I remember on the last sitting in December, my Lord gave directive that we file first. Then my Lord calculated our time, then calculated the time for the second defendant after calculating the first defendant after from the second defendant after calculating our time, then calculated that of the claimant lastly. That was the directive of my Lord on that day, my Lord. So it was sequential. The 21 days for us, 21 days for the first defendant, then 21 days for the claimant. That was when we arrived at March 1st. That was the directive of my Lord at that day.
Did you hear that, Hafiz?
Yes, my Lord. We are bound by the course directive, my Lord.
Okay.
But for the sake of knowledge, my Lord.
Mr. Odumi, your application is?
Yes, my Lord. It's dated 17th of January 2022.
It's dated when?
Yes, my Lord. 17th January 2022.
And filed when?
It was filed same day, my Lord.
On the 17th January 2022. Yes. Yes.
Well, this is a motion on notice pursuant to Order 17 Rule 1 of the National Industrial Court Rules and under the inherent jurisdiction of this Honorable Court. And we are praying for an order expanding the time granting the second defendant applicant leave to file and serve the defendant's counsel's closing address out of time. My Lord, I beg to move in terms. May it please the Lordship.
Abdul, any objection?
My Lord, there is no opposition to the objection.
Yes, Mr. Hafiz.
We are not
opposed. No objection, my Lord.
Yes, Abdul. No. Okay. Yes, Abdul. Abdul.
Yes, my Lord, we are not opposed to the application.
Okay, okay.
Oh, it's the other one for back on. That's what I did. After the first one, come on.
So, second defendant's application for extension of time to file its final written address dated and filed on the 17th of January 2022 is granted as spread.
As the court pleases.
Yes, Mr.
Yes, my lord.
Is
Our application also is dated 17th day of March 2022, my lord. And seeking the same relief from this honorable court, the order of the court granting extension of time for the claimants to file its final written address and serve same, and another that deeming the claimant's final written address already filed and served, as properly filed and served. If my lord will permit me to move in terms of the paper, my lord.
so your final written address was in respect of all the defendants' addresses.
As the court pleases, it captured the two defendants' addresses,
Okay.
my lord.
Okay.
Yes, my lord.
Yes, Mr. Abdul, any of
My lord, we have no objection.
Mr. Odun?
No objections, my lord.
Okay. So claimant's application for extension of time to file its final written address dated and filed on the 17th of March 2022 is granted as spread.
The court pleases.
As court pleases.
We are grateful, my lord.
Thank you. So adjourn to the next Friday for same time for the adoption.
As the court pleases.
As the court
Court pleases.
That is 25th of
Okay, 25th of March.
very well.
It's convenient, my lord. But if before my lord makes the final statement, I don't know if my lord should allow me to make further submission on the application for cost. There's no need for that any further, my lord.
What other submission do you want? What do you want to say?
I wanted to say that the need for cost did not arise in this instance, going by the antecedent that the second defendant's application for extension has just been granted now. So we are still within time. Even the last cost awarded, if the Milord can vacate that same cost, because we are still within time at that particular time. Yes, Milord has the power to vacate the order. It's within Milord's power to vacate the order, having been made an erroneous
No, the last cost was awarded against the first, or in favor of the first defendant. Not
yes,
the,
my lord.
Yes, because the defendant filed within time.
Yes, my lord, but on our misunderstood delay or misconceived delay, which we did not delay anything because we are still within our rights. So there was no any wrong done, which will warrant the cost against us in favor of the first defendant.
My
That's
Lord,
what we see
Mr.
with law.
Please can put an application to set aside that order.
Exactly.
He knows what to do. I say you can bring a formal application to set aside. The court cannot just set aside his order.
You didn't, Honorable, I mean, Lane Council, you didn't apply formally, you applied orally, and the court granted it. And I'm also making the same oral application.
But my Lord, the order of court is in writing. It is a procedure
And the
clearly
court will
stated
still
in the
write
rules
it.
as to how.
The court can still write it. It's an order of the courts.
So the date 2/5, is that okay? Hafiz, Abdullah, and Odum.
It's okay, my lord.
It's convenient, my lord.
Okay, so case is adjourned to the 25th of March 2022 for adoption of final written addresses via Zoom.
As the court praises.
Via the respective court.
As the court praises.
Yes. So, gentlemen, that will be all for today. And Hafiz, Abdullah, and Odum, I thank you so much, and I wish you a very good afternoon.
My lord.
Okay, thank you. The law school students. Yes, hello.
Good evening, my lord.
Yes, good evening. How are you?
Hi, my lord.
Yes.
Deborah,
Yeah.
sir.
Eh?
Deborah, sir.
Oh, okay, Deborah. How are you?
I'm fine, sir.
So, how are the Zoom proceedings?
It was very good, my lord. I was
Okay.
able to write down a lot of things, maybe
Okay.
because I could hear better than when I'm in court. From the back, I really can't hear proceedings, but I was able to hear very well today.
Okay, okay. Okay, thank you. I can see Bola. I can see Bola. I can also see Muna. Yes. Yes, any questions? Hello, gentlemen. Gentlemen, any questions? Hello, gentlemen, any questions, comments, or observation from the Zoom proceedings?
My lord, good evening, good afternoon, my lord.
Yes, good afternoon.
I have a question. The claimant's counsel mentioned that he was still within time to file his own written address. If that was the case, why was his application still taking?
No, he was within time to file in respect of the second defendant's address, because the second defendant too filed late, but the first defendant filed within time.
Okay.
Yes.
Thank you.
So he was out of time with respect of the first defendant. Okay, he was late with respect to the first defendant's final written address.
Okay, thank you, my lord.
Thank you. Yes, but did you notice something? If there are many defendants, if there are many defendants represented by different counsel, how is the written address going to be? Should the maybe first and second defendant, file their written address within that 21 days, or the second defendant has to wait first? Okay, so the first defendant has to wait first for the second to file before he files his own. Do you get the point?
Yes, my lord. I think
we have two defendants in this case, represented by different counsel. So how is the address going to be? I mean, the filing of the address.
My lord, I think it's supposed to be if the second defendant is the one who would file his own address first. Although the court may ask both defendants to file their written addresses concurrently. Like the court can ask them to do that, but I think normally it's supposed to be second defendant first, then after 21 days, the first defendant, then the claimant.
Okay. But we still, I will still check our rules and see whether that should be the order.
Okay, my lord.
Thank you. Yes. Yes. Any observation? Yes. 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 Robinson. Yes, Robinson is like, Robinson wants to talk. Yes. Yes. And any comment?
Sorry, my lord. And from what I heard, you didn't award any cost against
Yes, I didn't because of the.
Why not?
Yeah, the second defendant's application was today taken, so it's still, the claimant is still within time to file its address respect to the second defendant's final return address. That's why I didn't award that cost. Yeah, and I didn't feel that the defendants have to be compensated for anything, because as far as I'm concerned, it's a Zoom proceeding. Nobody can claim that he has you understand, suffered any inconvenience. Yes.
My lord, I observed that the claimant counsel was saying that he filed late due to the miscalculation on the part of the first defendant's counsel. So my question is it good practice to take advantage of your colleague's miscalculation when it comes to filing of processes?
The issue is that the claimant can't file until the defendants file. So if the defendant don't file, the claimant can't just go ahead and file his final return address. That is number one. And number two, since there is a pending application, from the side of the second defendant to extend time to file its final return address, the claimant is not bound to just go ahead and file, because time will begin to count from the date the application for extension of time is taken and granted. You understand? Like today, the claimant's counsel's time starts from today to file his final written address, irrespective of the second defendant's final address. Because it is today that the second defendant's application for extension of time was taken and granted. You get the point?
Yes, my lord. Thank you, my lord.
So the claimant is still within time to file his address with regards to the second defendant's final written address.
Okay, my lord.
Yes.
Thank you, my lord.
Thank you. Yes. Yes. So my question is that can final written addresses take the place of evidence or fact? Can council's final written address take the place of evidence? Yes, hello? Hello?
I don't think so, my lord.
Eh?
I don't think so.
Why?
Because I feel like the claimant still has to adduce his facts and like as evidence before, like the written address is like a compilation of everything that has been done. Like
Okay.
after the evidence has been given, then
Hasn't given
everything has
us
been done and his final submissions and arguments.
okay arguments here. So they can't take the place of some evidence of fact. But then can the final written addresses be dispensed with? Can the party decide to say we don't want to file our final written address, we just want judgment?
But doesn't the final written address give them the opportunity to like put their points before the court and
Yes,
their
but
submission?
they still say yes. Can they still say we have decided not to file our final written address, we just want judgment? Can they do that?
I don't know, but it seems like they are depriving themselves of an opportunity to. It seems like they are to do that will be to deprive themselves of the opportunity to like put their arguments before the court because
Yes,
evidence
but
alone they still have to like argue.
can any of the parties decide to say, I don't want to file any written address, I just want judgment? Or the court should give judgment, based on the fact that are presented. Can any person do that?
I don't know. I don't think so.
Why? Why don't you think so?
I don't know. I think it's something important. Because
Yes, it is. It is. It is important. But can't the can't the claimant's counsel, the defendant counsel decide to say, my lord, I don't want